and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. What have you been doing since I last saw you?
Well, we've just got off the final webinar of 2025. So I've made a cup of tea and I'm ready to go for what's nearly our final podcast of 2025.
Mm-hmm.
So we are here to talk about a case from the 9th of December from the Court of Appeal, and it's called London Borough of Tower Hamlets and Various Leaseholders of Brewster House and Maltings House. And it's all about something we've just been talking about with our local government audience on the webinar, repairing obligations and service charge, and in particular, sweeper up provisions. So do you want to start with the background facts to it all?
Yeah, I'll give you the history of it all, if you like. Yeah, it's in Tower Hamlets in London. And it's the Borough estate, which is probably gives you the lie to what used to be there. And it's now these two blocks of flats, Brewster House and Maltings House. There used to be a third block of flats there, but that was demolished. And they're basically council flats. They were sort of completed in 1967. And it's very common at the time. They used something in the actual building work called large panel systems. No one had gone into occupation in 1967, but more on that shortly. These large panel systems were sort of, as the name suggests, large panels of building material, concrete or whatever, which would then be bolted into place, forming the walls and the floors and ceilings of these properties. Before anybody had gone into occupation, nearby in Newham Borough Council, there was a disaster in May of 1968 involving a similar block of flats, a 22-storey block called Ronan Point, which was a national news story. It was a kind of 4 people were killed, but it was a kind of precursor to Grenfell. That was Ronan Point. And it seems that what had happened is that there'd been a gas explosion in one of the flats, but this panel system had failed as a consequence, and there was a partial collapse. Basically, there was found to be too much weight, put on the walls and likes, so they just gave way with disastrous consequences. So back in the late 60s and early 70s, all over the country, it wasn't uniquely councils, but people had to check their premises, high-rise buildings and likes. Again, sort of similar to Grenfell, to see if they had these large panel systems, and if so, to do remedial work on them. And work was done on Brewster House and Maltings House in the 60s and early 70s. And there was more work done in the early 1990s, between about 1990 and 94. But after Grenfell in June of 2017, people all over the country, people in landlords of blocks of flats, especially local authorities, were told that you have to inspect your premises and see everything's safe. And they found there was no problems with ACM, aluminium composites or metallic composite materials. There's no cladding issues in relation to fire safety. But it looked as if there was going to be a potential collapse again of the large panel systems. There'd been something similar had already happened in a block in Southwark in London. And anyway, they needed to do more work. They did some work and completed in 2020, but needed to do some more work, and they wanted to charge the leaseholders, the long leaseholders, via service charge over £9.2 million, not each, Lizzie, if that's what you're concerned about. But still, it was between 70,000 and 95,000 for these various tenants to pay. And they could only charge the long leaseholders. There's 112 flats in the block, but only 32 of them were held on long leases they bought under right to buy. Shall I explain why they can only charge the long leaseholders?
Yes.
It's because of sections 11 to 16 of the 1985 Landlord and Tenant Act, which basically says if you've got a lease of a dwelling of less than 7 years duration, the landlord must be responsible for wanted to keep in repair and proper working order. He's responsible for the structure and exterior, including drains, gutters, and external pipes, for the interior installations for gas, water, electricity, sanitation, and also for the interior installations in relation to space heating and water heating. So you're left with charging the long leaseholders, and it's basically down to what the service charge says.
So what did the Upper Tribunal say?
Well, the various leaseholders, these 32 leaseholders, they applied to the First-tier Tribunal under the 85 Landlord and Tenant Act, again, Section 27A, for basically a declaration as to whether this was covered via service charge and how much was covered. And the First-tier Tribunal and then the Upper Tribunal decided that, and the Court of Appeal for that matter as well, an appeal, decided, well, there was a sweeper provision, which we'll come back to, but landlords could charge for repairs and maintenance. And they looked at various cases, including 2 or 3 of the classic cases in terms of what's the repair or maintenance, because repairs and maintenance doesn't cover inherent defects, unless the inherent defect gives rise to disrepair for the watch, which you might be liable, which is a very complex point, actually. It depends so much on its individual facts. But I looked at a case, for instance, a case called Quick and Taffeely Borough Council from South Wales, Gridfellin in South Wales, where it was a badly designed council house, badly designed estate, not enough ventilation, and there was sort of metal window frames encased in concrete, so there was no sort of breathing or anything. And there was massive amounts of condensation, and the tenants wanted to sue the landlord under Section 11 of the 85 Act again. For it might have been its predecessor. There was a predecessor Housing Act of 1961, Sections 32 and 33, as I remember. And the court decided you can't sue because it's not an inherent, it's not disrepair, it's an inherently defective building. There might be other sort of public health implications, but you can't sue in damages. And there was a commercial example as well from the 80s, 1987, a case called Post Office and Aquarius Properties, which was a 22-year lease from the late 60s for a post office with the tenants. And there was a porous basement, and it would flood when the water table was sufficiently high. It became fairly useless, and the tenant was the one responsible for repairs, but the court decided this is not disrepair, it's been bad from day one, it's an inherent defect. And all the courts, including the Court of Appeal in this particular case, the Brewster House case, decided that exactly the same, it's an inherently defective building. It might go back almost 60 years to when the defects occurred in the building process, but it's still inherently defective. So that part failed for the council. But more troublingly, remember the Upper Tribunal decision? Just seemed to brush it under the carpet. But the Court of Appeal dealt with it in much more detail. One of the judges, Lord Justice Mayles, or the rest agreed with. And so there was a sweeper provision that the landlord could charge for all such works as in the absolute discretion of the lessors may be considered necessary for the safety of the building. So that seems, can they charge under that? This is necessary for the safety. And Lord Justice Mayles said that the work is obviously for safety reasons, but that doesn't make it, that doesn't mean it's you're liable for pre-existing structural defects which were in existence before the lease was entered into. They said that, safety, for instance, within the lease had been defined as various things that you could charge for in relation to this building. And there were sort of mundane, everyday maintenance, if you like, or everyday administration, charging for a caretaker and charging for cleaners and changing light bulbs and this kind of thing. And it therefore didn't envisage something as significant as extreme structural safety. You'd need much more clear wording before you could do that. And there was also total expenditure clause. This is what we can spend money on. That referred to maintenance and the likes, but it didn't refer to, again, structural matters. So for those various reasons, they said it would be inconceivable that the words allowed recovery of costs, which should positive obligation for the local authority to make, the landlord to make anyway. These obligations under the original have been replaced by other provisions since, but under the Housing Act, the 85 Housing Act, which say that the landlord's obliged to do this work anyway. So unless you've got incredibly clear wording, you can't add the cost to service charge, and you haven't got incredibly clear wording. That's basically the idea, and what the Court of Appeal said.
So why is this one so significant then, Richard?
Well, they said a few other things. That, unlike the Upper Tribunal, they did actually say that you could also take into account the background legislation. It's a right to buy. So whether it applies elsewhere is another matter. But the original right to buy legislation in the 1980 Housing Act and then the 1985 Housing Act, you've got to put it in its statutory context, not least of which that the landlord knew about the defects. He didn't know how significant the defects were when the leases were first granted. And also, you've got to look at the tenants need to be protected against, basically safety issues and such onerous financial burdens. And therefore, that sweeper-up provision is not going to be of any effect whatsoever.
Any final things to say on this one?
Yeah, so it's very, very significant across the board. I suspect not just for councils and right to buys and not just for long residential leases either, and making sure that landlords get the service charge wording. Admittedly, the fact it's a right to buy flat was a telling point in it. But it's not just about things like large panel systems. You can say lots of inherent defects out there going back many a year. The one that springs to mind is, do you remember reinforced autoclaved aerated concrete rack?
This is the concrete that they found in a load of schools, isn't it?
Yeah, I think it was in 2023, wasn't it? The Scotland school term. Then there were problems in 2024 as well. It's a sort of cheaper version than normal concrete that was used a lot throughout I think from about the 1950s right into the 1990s. And it just seems to flake away. And as you said, they found it in schools all over the place. It's used in offices. It's used in all kinds of buildings, or was back in the day. And there's huge issues at the moment pending. If it's leasehold, who's going to be responsible for that? And it's going to be a similar kind of argument. Is it an inherent defect, even if it goes back 60 years? Is it more significant? Is it in disrepair? And if you can show the inherent defect caused disrepair, again, it's an issue. Well, you might be able to pin the blame on the person responsible for repairs. Otherwise, landlords are going to be very much out of pocket on that as well. There's all various other things as well. We did a podcast recently on Al McCantor Centrepoint House, and was it Penelope de Volk? Sounds posh. Where it was about not being able to charge the qualifying leaseholders under the Building Safety Act for removal of cladding on Centrepoint House in London, which went back for 60 years, but you can charge the non-qualifying leaseholders, presumably, depending on what the service charge says. So there's lots of issues out there. I say a lot of the case law, or a lot of the problem areas, not the case law, goes back to developments in the 1950s and 60s and 70s. And it's an important one, Lizzie.
Thank you very much, Richard. Did you want to end with the joke that you've just told in the webinar? It was a great joke, so we should share it.
I didn't like that joke.
I think the bar for cracker jokes is quite low.
But here's what I prepared earlier. What kind of a dog is best at pulling a sleigh?
I don't know. What kind of dog is best at pulling a sleigh?
Sausage dogs. They go dachshund through the snow.
You can have a sympathy laugh for that joke, and that's all you're getting out of me.
I suppose it's Dachshund, if I should. It's pronounced Dachshund. Badger hound.
Well, thank you very much, Richard.
Okay, thanks, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.